Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only and does not constitute legal, financial, or professional mental health advice. Marriage, divorce, and family laws vary significantly by state and jurisdiction, and the trends discussed may not apply to your specific legal or personal situation. The legal system is complex and high stakes. Therefore, viewers are strongly encouraged to conduct their own due diligence and consult with a licensed attorney, a certified financial planner, or a qualified therapist before making any life-altering decisions. Do not rely on this content as a substitute for professional counsel tailored to your circumstances. In the next 20 minutes, you are going to witness the dismantling of a century-old social contract. For decades, the American man was sold a specific blueprint for success. Work hard, marry for life, and build a legacy. But as we move further into 2026, that blueprint has been shredded by a legal and cultural machine that many men do not realize exists until they are already caught in its gears. Imagine a system where the very person you promised to protect can end the partnership at any moment, for any reason or no reason at all, while the state steps in to enforce a financial distribution that can feel more like a penalty than a settlement. This isn't just about bad luck. It is about a systemic shift in the way the United States handles the dissolution of the family. If you are a man in America today, you are operating in a landscape where nearly 70% of all divorces are initiated by women, a statistic that climbs even higher among college-educated demographics. This video is the first part of a deep dive masterclass designed to pull back the curtain on why this is happening, the historical trends that led us here, and the potential outcomes you need to understand to protect your future. To understand where we are in 2026, we have to look back at the radical transformation of American family law that began in the late 1960s. Before 1969, divorce in America was largely based on a fault-based system. If you wanted to end a marriage, you had to prove a specific violation: adultery, physical cruelty, or abandonment. This created a high barrier to entry for the legal system, which in turn fostered a culture of marital endurance. However, in 1969, California Governor Ronald Reagan signed the first No-Fault Divorce Act. This was intended to reduce the perjury and acrimony involved in fabricated fault claims, but it inadvertently sparked a national domino effect. By the mid-1980s, every state in the Union had some form of no-fault legislation. In this new era, the concept of irreconcilable differences became the gold standard. This means that a marriage can be dissolved based on the subjective feelings of one party, without any requirement to prove the other party did something wrong. +2. For the modern American man, this shift represents a fundamental loss of leverage. Historical trends show that when the legal barrier to exit was lowered, the rate of divorce spiked. In the present day, we see a refined divorce rate of approximately 14.9 per 1,000 married women. While some point to this as a sign of progress and personal freedom, others view it as the commodification of the marriage contract. The self-actualization marriage model has replaced the traditional economic unit model. Today, a spouse is often viewed as a vehicle for personal growth. When that growth stalls, the contract is often terminated. Case studies from recent years suggest that many men are blindsided by this because they still operate under the economic unit mindset, believing that as long as they provide and protect, the marriage is secure. The data suggests otherwise. Beyond the cultural shift lies a massive state-run financial engine, known as Title 4D of the Social Security Act. This is a part of the divorce process that few men understand until they are sitting in a courtroom. Title 4D creates a federal-state partnership where the federal government provides incentive payments to states based on the amount of child support they collect. This creates a potential conflict of interest within the state administrative system. When a court orders a higher child support payment, the state may receive more federal funding. This divorce industrial complex isn't just a conspiracy theory. It is a documented administrative structure. In 2026, states are still operating under these guidelines, which can lead to a standard where the best interests of the child are often interpreted in a way that maximizes the financial flow through state agencies. For a man, this often means that his role is legally reduced from a father to a non-custodial parent, whose primary contribution is a monthly electronic transfer. The financial checkmate is often completed by the division of assets and spousal support, commonly known as alimony. While some states have moved toward rehabilitative alimony, designed to help a spouse get back on their feet for a limited time, many jurisdictions still allow for long-term or permanent alimony based on the standard of living established during the marriage. If you are a high earner, You may find yourself in a situation where you are legally obligated to fund a lifestyle for a person who no longer wishes to be in a relationship with you. Historical trends in asset division, particularly in community property, states like California or Texas, typically mandate a 50-50 split of all marital assets. This includes retirement accounts, home equity, and even business valuations. Case studies of professional men in their 40s and 50s show that a divorce at this stage can wipe out 20 years of wealth accumulation in a matter of months. The psychological impact of this shift is equally staggering. Data from the Centers for Disease Control and the American Psychological Association indicates that men are significantly more likely to suffer from first-onset major depression following a marital disruption compared to women. This is often because men tend to tie their identity and their social circle more closely to their nuclear family. When a divorce occurs, a man may lose not just his wife, but his home, his daily access to his children, and 50 to 70% of his social support network. In 2026, we are seeing a crisis of connection among divorced men, leading to higher rates of substance use and isolation. The historical trend of the stoic man, who suffers in silence, is proving to be a dangerous relic in a legal system that moves at a lightning-fast bureaucratic pace. Furthermore, we must address the silver tsunami, or gray divorce trend. While overall divorce rates have stabilized or even dropped among younger generations, the rate for those over the age of 50 has nearly doubled since the 1990s. For men in this age bracket, the stakes are at their absolute highest. You are closer to retirement, your ability to re-earn lost capital is diminished, and the legal system is less likely to show leniency regarding spousal support because of the length of the marriage. These cases often involve complex, qualified domestic relations orders, or QDROs, which are legal instruments used to split pension and 401k plans. A man who has worked 30 years for a specific pension may find half of it diverted before he even sees his first retirement check. This deep dive masterclass is not here to paint a picture of hopelessness, but to provide a grounded, educational look at the reality of the 2026 landscape. The goal is to move from a state of reactive shock to one of proactive understanding. We will explore the potential outcomes of mediation versus litigation, the importance of pre-divorce planning, and how the shifting laws in states like Louisiana and Texas, which are currently debating the limitation of no-fault divorce, could change the game for everyone. By understanding the data, the historical trends, and the administrative incentives, you can navigate this shift without losing your financial foundation or your mental health. This is part one of our journey into the reality of the American divorce machine. Stay focused, because the details we cover in the next sections could save you years of legal heartache and a lifetime of financial regret. The first thing you must understand as we step into this second module is that the American legal system does not reward the nice guy. It rewards the prepared guy. To navigate the landscape of 2026, you have to look past the surface-level advice found on basic forms and understand the specific legal trap known as the status quo doctrine. In the eyes of a family court judge, the current living arrangement is the most stable environment for the children. If you find yourself in a deteriorating marriage and decide to move out of the family home to give your spouse some space or to avoid conflict, you may have unintentionally signed away your primary custody rights. Imagine a man named Mark, 42-year-old project manager living in a suburb of Charlotte, North Carolina. It is March 2026, and after 15 years of marriage, Mark and his wife Sarah are essentially living as roommates. The tension is thick, the silence is deafening, and Mark decides that the most honorable thing to do is to pack a bag and move into a short-term rental down the street. He thinks he is being a gentleman. He thinks he is lowering the temperature. In reality, Mark has just handed the court a historical trend that suggests Sarah is the primary caregiver, and he is merely a visitor. By leaving the residence, Mark has established a new status quo where the children live with their mother and see their father on weekends. When the case finally reaches a judge 6 months later, the court is hesitant to disrupt this established routine. This is not a guess. This is a potential outcome based on thousands of case studies where men prioritized emotional comfort over legal strategy. In 2026, the cultural shift has moved toward a hyper-awareness of emotional labor and weaponized incompetence. These terms, which began as social media buzzwords, have now entered the courtroom. Lawyers for the initiating spouse will often use your high-pressure career against you, arguing that because you worked 60 hours a week to provide the very lifestyle they are currently enjoying, you were an absentee parent. They will use the historical trend of your absence at school plays or pediatrician appointments as evidence that you are not fit for a 50-50 custody split. To counter this, you must begin a process of active documentation long before a single legal paper is filed. Step 1 in this deep dive strategy is the implementation of a parenting log. In the 2026 legal climate, your word means very little without a digital or physical paper trail. If you are the one who wakes the children up, makes their breakfast, and drives them to school, you need to record it. If you are the one attending soccer practices or helping with 2026-era advanced STEM homework, it must be noted. This is not about being petty. It is about providing the court with a factual counter-narrative to the absentee father trope. Case studies show that fathers who can present a detailed, 6-month log of their daily involvement are significantly more likely to secure a true 50-50 parenting plan. Next, we have to address the digital forensic footprint. We are living in an era where your smart home is a witness. In many 2026 divorce cases, data from Nest thermostats, Ring doorbells, and even smart refrigerator logs are being subpoenaed to prove or disprove residency and behavior. Imagine if your spouse claims you are never home, but your phone's location data and the smart lock logs show you arriving at 5:15 p.m. every day for the last 3 years. This data is objective, does not have feelings. It cannot be manipulated by an angry spouse's testimony. You must ensure that you have access to these accounts and that the data is being backed up. Many men make the mistake of letting their spouse manage the digital life of the house, only to find themselves locked out of the very evidence that could prove their presence and involvement. Historical trends also show a massive shift in how spousal maintenance is calculated in the current year. While many states are moving toward more restrictive alimony laws, the 2026 standard still heavily favors the lower-earning spouse if the marriage has lasted more than 10 years. This is where the standard of living argument becomes a financial anchor. If you have spent the last decade providing a lifestyle that includes luxury vehicles, private schools, and international vacations, the court may view it as your legal obligation to continue funding that level of existence for your ex-spouse, regardless of their ability to work. To mitigate this potential outcome, you must perform a pre-litigation financial audit. You need to understand every dollar that flows in and out of your household. Many men are shocked to find out that their household expenses are 30% higher than they thought, because they delegated the finances to their spouse. In a divorce, that 30% error could be the difference between a comfortable future and a decade of debt. We also have to discuss the rise of social media influence on the divorce rate in 2026. There is a documented cultural phenomenon where women are encouraged by online communities to seek a divorce glow up. These communities often present divorce as a consequence-free path to self-discovery, fueled by the potential of a significant asset split. For the man in the middle of this, it feels like his partner has been replaced by a stranger who is following a script. This is why you cannot rely on the person you married to be the person you divorce. The historical trend of the amicable separation is becoming a rarity in a high-conflict, high-incentive legal environment. Step 2 in your masterclass preparation is the financial firebreak. This involves securing your individual credit and ensuring that marital funds are not being liquidated or hidden. In 2026, we see a rise in cryptocurrency concealment and the use of digital payment apps to move money out of reach before a filing. If you see your spouse suddenly opening new bank accounts, or if there is a sudden decrease in the transparency of your joint accounts, these are red flags that a filing is imminent. You must gather 3 years of tax returns, 5 years of bank statements, and all retirement account information immediately. You are not doing this to be deceptive. You are doing this because in the discovery phase of a 2026 divorce, these documents are often the first things to go missing or become difficult to obtain. Imagine another scenario with a character named David, a 50-year-old engineer in Seattle. David noticed his wife became increasingly secretive with her phone and started frequenting high-end fitness retreats. Instead of confronting her emotionally, David consulted with a forensic accountant. They discovered that over the course of 18 months, his wife had moved nearly $40,000 into a separate account under the guise of household expenses. Because David caught this before the filing, he was able to present this as wasteful dissipation of marital assets during the settlement phase. If he had waited, that money would have been gone, and he would have been fighting for a 50% share of what was left, rather than a credit for what was taken. The 2026 landscape requires a man to be a diplomat in the house but a general in the shadows. You must maintain the peace at all costs during this pre-filing phase. Any outburst, any loss of temper, or any aggressive text message can and will be used as a high-stakes piece of evidence to secure a temporary restraining order. In many jurisdictions, a TRO is granted with very little evidence, and it immediately removes you from your home and your children. Once that order is in place, you are fighting an uphill battle from a position of weakness. As we conclude this part of our deep dive, you should be starting to see that divorce in America is a game of information and positioning. We have covered the trap of moving out, the power of the parenting log, the reality of digital evidence, and the necessity of a financial audit. But there is a darker side to this process that we haven't touched on yet. A tactic used to gain an immediate, devastating advantage in the first 48 hours of a case. In the next part, we are going to expose the false allegation minefield. You will learn exactly how the 2026 legal system handles accusations of domestic instability, why your phone's voice recorder might be your most important tool, and the specific steps you must take to ensure you are never removed from your home on a whim. The rules of engagement have changed, and if you don't know the next set of traps, you are walking into a disaster. The false allegation minefield is the most dangerous territory a man will ever navigate in the American legal system. In 2026, we are seeing the peak of what legal scholars call the silver bullet technique. This is a strategic move where one party levels an accusation of domestic instability or personal threats to gain an immediate, tactical advantage in a divorce proceeding. Under the current legal framework in the United States, the threshold for obtaining a temporary restraining order, or TRO, is remarkably low. Because the court system prioritizes immediate safety, these orders are often granted ex parte, which is a legal term meaning they are issued based on the testimony of only one side without you even being present to defend yourself. Imagine a man named Kevin, a 45-year-old software engineer living in Austin, Texas, in June 2026. Kevin has never had a run-in with the law. He has no history of aggression. One Tuesday evening, after a tense but non-physical argument about the children's summer camp, Kevin goes to sleep in the guest room. At 7 a.m. the next morning, there is a knock at the door. It is a process server accompanied by local law enforcement. Kevin is handed a stack of papers and told he has 15 minutes to gather his essentials and vacate the premises. He is prohibited from contacting his wife and, most devastatingly, his 2 young daughters. This is not a final judgment of guilt. It is a temporary order. However, in the high-stakes environment of 2026, temporary often becomes the new permanent. The potential outcomes of such a move are catastrophic for a man's legal standing. Once you are removed from the home via TRO, the status quo we discussed in the previous module shifts instantly. Your spouse now has exclusive possession of the residence and primary physical custody of the children. By the time you get your day in court, which due to 2026 court backlogs, could be 3 to 6 weeks away, the children have become accustomed to you not being there. The court may then view a return to a 50-50 arrangement as a disruption to the children's new routine. This is the historical trend of the legal system. It moves slowly to correct an error, but quickly to establish a restriction. To survive this, you must understand the concept of tactical situational awareness. In 2026, your home is no longer just your sanctuary. It is a potential crime scene in a civil litigation battle. Case studies from 2025 and early 2026 show that the most successful defenses against the silver bullet involve the use of passive documentation. In many states, specifically those with one-party consent recording laws, men are increasingly utilizing small, unobtrusive digital voice recorders or even their smartphones to record all interactions within the home once a divorce becomes imminent. Consider the case of Marcus, a father in Florida. Sensing that his marriage was heading toward a high-conflict dissolution, Marcus began recording his interactions with his spouse whenever they were in the same room. When his wife eventually called the police and claimed he had cornered her and threatened her, Marcus was able to provide his attorney with a clear, calm audio file of the entire evening. The recording showed Marcus was actually in the kitchen doing dishes while his spouse yelled at him from another room. This piece of evidence didn't just prevent the TRO. It fundamentally destroyed the spouse's credibility for the remainder of the asset division and custody hearings. In the 2026 legal climate, an objective digital witness is often the only thing standing between a man and a total loss of his parental rights. However, you must be extremely careful with the legality of these recordings. The United States is a patchwork of wiretapping laws. Some states, like Texas and Florida, have vastly different rules regarding when and where you can record a conversation. This is why conducting your own due diligence and consulting with a local attorney is non-negotiable. If you are in a two-party consent state, recording without permission can actually lead to criminal charges, which would play directly into the hands of a high-conflict spouse. In those jurisdictions, Men are instead turning to third-party witnesses. Having a friend, a family member, or even a professional supervisor present during exchanges, or while living in the same house can serve as a human shield against false narratives. Another deep dive strategy for 2026 is the use of your own digital footprint to establish a counter-alibi. We are seeing a historical trend where Google Maps timeline data, Apple Health heart rate logs, and even smart home interaction logs are used as evidence. Imagine if an allegation is made that an incident occurred at 9 p.m. on a Saturday. If your Apple Watch shows a resting heart rate of 60 beats per minute, and your PlayStation account shows you were logged into a game with friends at that exact time, the allegation begins to crumble under the weight of objective data. In 2026, your life is data mined by corporations. It is only logical that you use that same data to protect your reputation. Step by step, if you find yourself served with a TRO, the first rule is absolute compliance. Do not argue with the officers. Do not try to explain your side to them on the front porch. In the 2026 judicial system, anything you say to a responding officer will be summarized in a police report that will be read by the judge later. If the report says you were agitated, loud, or uncooperative, it reinforces the narrative of the aggressive male. The most effective response is a calm, silent exit. Once you are off the property, you immediately contact a specialized high-conflict divorce attorney. You must also be aware of the gray area allegations. In 2026, courts are moving beyond just physical abuse and are increasingly looking at coercive control. This is a broad legal term that can include monitoring a spouse's spending, questioning their whereabouts, or even emotional withdrawal. While these laws were intended to protect victims of systemic abuse, they are often used in family court to pathologize standard marital conflict. To defend against this, your documentation must show a pattern of reasonable behavior. If you are questioning spending because the joint account is overdrawn, keep the bank statements that prove the financial necessity of the conversation. Context is your best friend in a courtroom, and in 2026, the person with the best organized context wins. The psychological toll of being falsely accused cannot be overstated. Historical trends indicate that men who face these allegations often experience a form of acute stress disorder. This can lead to mistakes, such as sending a long-winded or angry text message to the spouse trying to clear your name. In the eyes of a 2026 judge, that text message is not a man defending his honor. It is evidence of harassment. The rule for 2026 is simple. Once the legal process starts, all communication must go through a parenting app like Our Family Wizard or Talking Parents. These apps create a court-admissible record of every interaction and discourage the high-conflict baiting that leads to TROs. As we peel back the layers of this system, you are starting to see that the American divorce machine is designed to react to the loudest voice. By staying calm, recording the truth where legal, and utilizing your digital alibi, you can survive the initial strike. But even if you keep your home and your reputation, there is a second, more silent strike coming. It happens in the dark corners of your bank accounts and retirement funds. Once the silver bullet fails, the next phase of the 2026 divorce strategy is financial decapitation. This is a coordinated effort to drain your resources so you cannot afford the very legal defense we just discussed. In the next part, we are going to dive into the forensic paper trail. You will learn how to spot the hidden signs that money is being moved, why your 401k is a sitting duck, and the one specific banking move you must make the moment you suspect the marriage is over to ensure you aren't left penniless before the first hearing. The battle for your children is fought with evidence, but the battle for your future is fought with math. Stay tuned because the next 10 minutes could determine if you retire in comfort or work until the day you die. The false allegation minefield is the most dangerous territory a man will ever navigate in the American legal system. In 2026, we are seeing the peak of what legal scholars call the silver bullet technique. This is a strategic move where one party levels an accusation of domestic instability or personal threats to gain an immediate, tactical advantage in a divorce proceeding. Under the current legal framework in the United States, the threshold for obtaining a temporary restraining order, or TRO, is remarkably low. Because the court system prioritizes immediate safety, these orders are often granted ex parte, which is a legal term meaning they are issued based on the testimony of only one side without you even being present to defend yourself. Imagine a man named Kevin, a 45-year-old software engineer living in Austin, Texas, in June 2026. Kevin has never had a run-in with the law. He has no history of aggression. One Tuesday evening, after a tense but non-physical argument about the children's summer camp, Kevin goes to sleep in the guest room. At 7 a.m. the next morning, there is a knock at the door. It is a process server accompanied by local law enforcement. Kevin is handed a stack of papers and told he has 15 minutes to gather his essentials and vacate the premises. He is prohibited from contacting his wife and, most devastatingly, his 2 young daughters. This is not a final judgment of guilt. It is a temporary order. However, in the high-stakes environment of 2026, temporary often becomes the new permanent. The potential outcomes of such a move are catastrophic for a man's legal standing. Once you are removed from the home via TRO, the status quo we discussed in the previous module shifts instantly. Your spouse now has exclusive possession of the residence and primary physical custody of the children. By the time you get your day in court, which due to 2026 court backlogs, could be 3 to 6 weeks away, the children have become accustomed to you not being there. The court may then view a return to a 50-50 arrangement as a disruption to the children's new routine. This is the historical trend of the legal system. It moves slowly to correct an error, but quickly to establish a restriction. To survive this, you must understand the concept of tactical situational awareness. In 2026, your home is no longer just your sanctuary. It is a potential crime scene in a civil litigation battle. Case studies from 2025 and early 2026 show that the most successful defenses against the silver bullet involve the use of passive documentation. In many states, specifically those with one-party consent recording laws, men are increasingly utilizing small, unobtrusive digital voice recorders or even their smartphones to record all interactions within the home once a divorce becomes imminent. Consider the case of Marcus, a father in Florida. Sensing that his marriage was heading toward a high-conflict dissolution, Marcus began recording his interactions with his spouse whenever they were in the same room. When his wife eventually called the police and claimed he had cornered her and threatened her, Marcus was able to provide his attorney with a clear, calm audio file of the entire evening. The recording showed Marcus was actually in the kitchen doing dishes while his spouse yelled at him from another room. This piece of evidence didn't just prevent the TRO. It fundamentally destroyed the spouse's credibility for the remainder of the asset division and custody hearings. In the 2026 legal climate, an objective digital witness is often the only thing standing between a man and a total loss of his parental rights. However, you must be extremely careful with the legality of these recordings. The United States is a patchwork of wiretapping laws. Some states, like Texas and Florida, have vastly different rules regarding when and where you can record a conversation. This is why conducting your own due diligence and consulting with a local attorney is non-negotiable. If you are in a two-party consent state, recording without permission can actually lead to criminal charges, which would play directly into the hands of a high-conflict spouse. In those jurisdictions, men are instead turning to third-party witnesses. Having a friend, a family member, or even a professional supervisor present during exchanges, or while living in the same house can serve as a human shield against false narratives. Another deep dive strategy for 2026 is the use of your own digital footprint to establish a counter-alibi. We are seeing a historical trend where Google Maps timeline data, Apple Health heart rate logs, and even smart home interaction logs are used as evidence. Imagine if an allegation is made that an incident occurred at 9 p.m. on a Saturday. If your Apple Watch shows a resting heart rate of 60 beats per minute, and your PlayStation account shows you were logged into a game with friends at that exact time, the allegation begins to crumble under the weight of objective data. In 2026, your life is data mined by corporations. It is only logical that you use that same data to protect your reputation. Step by step, if you find yourself served with a TRO, the first rule is absolute compliance. Do not argue with the officers. Do not try to explain your side to them on the front porch. In the 2026 judicial system, anything you say to a responding officer will be summarized in a police report that will be read by the judge later. If the report says you were agitated, loud, or uncooperative, it reinforces the narrative of the aggressive male. The most effective response is a calm, silent exit. Once you are off the property, you immediately contact a specialized high-conflict divorce attorney. You must also be aware of the gray area allegations. In 2026, courts are moving beyond just physical abuse and are increasingly looking at coercive control. This is a broad legal term that can include monitoring a spouse's spending, questioning their whereabouts, or even emotional withdrawal. While these laws were intended to protect victims of systemic abuse, they are often used in family court to pathologize standard marital conflict. To defend against this, Your documentation must show a pattern of reasonable behavior. If you are questioning spending because the joint account is overdrawn, keep the bank statements that prove the financial necessity of the conversation. Context is your best friend in a courtroom, and in 2026, the person with the best organized context wins. The psychological toll of being falsely accused cannot be overstated. Historical trends indicate that men who face these allegations often experience a form of acute stress disorder. This can lead to mistakes, such as sending a long-winded or angry text message to the spouse trying to clear your name. In the eyes of a 2026 judge, that text message is not a man defending his honor. It is evidence of harassment. The rule for 2026 is simple. Once the legal process starts, all communication must go through a parenting app like Our Family Wizard or Talking Parents. These apps create a court-admissible record of every interaction and discourage the high-conflict baiting that leads to TROs. As we peel back the layers of this system, you are starting to see that the American divorce machine is designed to react to the loudest voice. By staying calm, recording the truth where legal, and utilizing your digital alibi, you can survive the initial strike. But even if you keep your home and your reputation, there is a second, more silent strike coming. It happens in the dark corners of your bank accounts and retirement funds. Once the silver bullet fails, the next phase of the 2026 divorce strategy is financial decapitation. This is a coordinated effort to drain your resources so you cannot afford the very legal defense we just discussed. In the next part, we are going to dive into the forensic paper trail. You will learn how to spot the hidden signs that money is being moved, why your 401k is a sitting duck, and the one specific banking move you must make the moment you suspect the marriage is over to ensure you aren't left penniless before the first hearing. The battle for your children is fought with evidence, but the battle for your future is fought with math. Stay tuned because the next 10 minutes could determine if you retire in comfort or work until the day you die. Financial decapitation is not just a hyperbolic term. In the high-speed digital economy of 2026, it is a clinical, tactical maneuver designed to strip a man of his ability to defend his interests before the first court date even arrives. When we talk about the battle for your future being fought with math, we are referring to the reality that a legal defense in a high-conflict American divorce can cost anywhere from $20,000 to over $100,000 in retainer fees and forensic costs. If your liquid assets are seized or frozen in the opening moves, your ability to hire the caliber of counsel needed to protect your parental rights in retirement is effectively neutralized. Historical trends in 2026 show that the first 72 hours following a domestic split are the most volatile for marital finances. Imagine a man named James, a 51-year-old senior systems architect living in Denver, Colorado. In April 2026, James arrives home to find that his wife has not only moved out but has also cleared their joint savings account of $85,000. This was the money James had earmarked for their children's college fund and their emergency savings. Because the account was joint, the bank views both parties as having 100% ownership. No laws were technically broken in the eyes of the financial institution. When James attempts to hire a top-tier family law firm the next morning, he is asked for a $15,000 initial retainer. With his primary savings gone and his credit card suddenly maxed out by his spouse's sudden spending spree on high-end furniture for her new apartment, James finds himself financially paralyzed. This is a common case study in modern American divorce. The use of marital funds to fund one side's legal attack while simultaneously starving the other side's defense. To avoid the potential outcome of total liquidity loss, men in 2026 are increasingly utilizing the strategy of the financial firebreak. This involves the immediate, transparent relocation of exactly 50% of joint liquid assets into a new individual account at a completely different financial institution. In the legal climate of 2026, doing this at the moment of separation, or even slightly before a planned filing, is often viewed by courts as a reasonable act of self-preservation rather than an attempt to hide assets, provided the move is fully disclosed in the initial financial affidavits. By moving exactly half, you are signaling to the court that you are not seeking to deprive your spouse of their share, but rather ensuring that you have the resources to survive and litigate. If James had implemented a firebreak, he would have had $42,000 secured in an account his spouse could not touch, ensuring his legal representation was solidified from day one. Beyond the immediate cash grab, the 2026 divorce machine targets the long-term wealth engine, the 401k and the IRA. For many American men, their retirement account is their largest single asset, often eclipsing the equity in their home. The historical trend in community property and equitable distribution states is to view all contributions made during the marriage as marital property. In 2026, the tool used to extract these funds is the Qualified Domestic Relations Order, or QDRO. A QDRO is a specialized legal instruction that tells a plan administrator to bypass the standard rules against early withdrawal or transfer and hand over a specific percentage of your retirement to your ex-spouse. The danger in 2026 lies in the valuation of these accounts. Many men fail to account for the tax implications of a 401k split. If you are ordered to give 50% of a $500,000 401k to your spouse, you aren't just losing $250,000 of your future. Because that money is often pre-tax, the person receiving the funds via QDRO can often roll it into their own IRA without immediate tax penalties, while you are left with a smaller principal that has a massive future tax liability attached to it. Case studies from 2025 suggest that high-earning men who do not insist on a tax-impacted valuation of their retirement accounts end up losing significantly more than the face value percentage suggests. You must ensure that your forensic accountant calculates the net after-tax value of all assets to ensure a truly equitable split. We also have to address the 2026 reality of debt loading. This is a tactic where a spouse, sensing an impending divorce, begins to rack up significant consumer debt on joint credit cards. Under the historical legal standards of many states, debt incurred during the marriage is considered a joint liability, regardless of who signed the receipt. Imagine if your spouse buys $40,000 worth of jewelry, vouchers, and designer clothing 3 weeks before filing for divorce. In the eyes of a busy family court judge, this may simply be lumped into the total marital debt, meaning you are now responsible for $20,000 of her pre-divorce shopping spree. To counter this, a proactive step involves the immediate notification of all creditors. In 2026, you can place a freeze on joint lines of credit or send a formal letter of revocation to credit card companies, stating that you will no longer be responsible for any charges made by the other party. This doesn't always stop the spending, but it creates a definitive line in the sand that your attorney can use to argue that the debt was incurred in bad faith and should be assigned solely to the spouse. The most advanced layer of the 2026 financial battle is the lifestyle audit. In an era of digital payments, Venmo, and cryptocurrency, hiding money has become both easier and more dangerous. Forensic accountants in 2026 now use AI-integrated software to scan 3 to 5 years of bank statements, looking for patterns that don't add up. They look for the cashback trick, where a spouse goes to a grocery store, spends $50 on food, but asks for an extra $100 in cashback at the register. Over 3 years, a weekly $100 cashback withdrawal adds up to over $15,000 in untraceable mattress money. If you are not performing your own audit of the household records, you might find yourself paying alimony based on an inflated sense of your spouse's financial need, while they are sitting on a hidden pile of cash you helped fund. Step by step, the 2026 Financial Survival Guide for Men requires a shift from trust to verification. First, you must gather every statement for every account you have touched in the last 7 years, as many jurisdictions are expanding their look-back periods. Second, you must identify every recurring automatic payment. Many men are financially bled dry during a divorce because their spouse continues to use the joint account for subscriptions, insurance premiums, and utility bills for a new residence. Third, you must understand the automatic temporary restraining orders, or ATROs, which go into effect in many states the moment a divorce is filed. These orders legally freeze the marital estate, preventing either party from hiding or transferring assets. If you do not have your firebreak in place before the ATROs are served, you are stuck with whatever balance is in your account regardless of your needs. The financial pressure is often designed to break your spirit, so you will agree to a lopsided custody arrangement just to make the litigation stop. This is where the math meets the psychology. A man who is worried about how he will pay rent is a man who is more likely to settle for every other weekend visitation just to avoid another $10,000 legal bill. You must realize that your financial security is the foundation of your parental rights. Without the funds to stay in the fight, the legal system will default to the path of least resistance, which historically has not favored the father. As we move forward, it is clear that the financial landscape of 2026 is a maze of digital traps and administrative hurdles. But while the loss of money is painful, it is recoverable. There is something else, however, that is far more difficult to rebuild once it is broken. As the financial battle reaches its peak, many men find themselves facing a new, more sinister form of warfare that targets their very relationship with their children. In the next part of this masterclass, we are going to dive into the world of parental alienation and the gatekeeping tactics that are being refined in 2026. You will learn the subtle signs that your children are being coached, the specific phrases to look for in their conversation, and the one legal move you must make to stop the poisoning of your legacy before it becomes permanent. The math was just the beginning. Now we fight for the heart of the family. Parental alienation in 2026 is no longer a fringe psychological theory. It has evolved into a sophisticated form of interpersonal warfare that legal professionals now categorize under the umbrella of restrictive gatekeeping. When we talk about fighting for the heart of the family, we are addressing the systematic erosion of the bond between a father and his children, often orchestrated through subtle, repetitive psychological conditioning. In the current American legal landscape, this is the most difficult form of interference to prove, yet it carries the most devastating potential outcomes for your long-term relationship with your legacy. Historically, courts have been slow to recognize the nuance of alienation, often mistaking it for a child's natural preference. However, the data in 2026 shows a shift toward recognizing that a child's sudden unexplained rejection of a once-loved parent is almost always a learned behavior. To understand how this functions in real time, imagine a man named Robert, a 46-year-old healthcare administrator in Phoenix, Arizona. Robert has always been a hands-on father, coaching his son's baseball team and taking his daughter to her weekend violin lessons. When the divorce proceedings began in early 2026, the atmosphere shifted. Robert began to notice that when he arrived for his scheduled parenting time, the children were suddenly sick, had too much homework, or simply refused to come out of the house. His spouse would stand at the door, shrug, and say, "I am not going to force them if they do not want to go. I have to respect their feelings." This is the 2026 version of restrictive gatekeeping. It uses the language of modern, child-centered parenting as a shield to justify the violation of a court-ordered schedule. The historical trend here is a move away from overt badmouthing toward what experts call the therapeutic mask. Instead of telling the children that their father is a bad person, an alienating parent in 2026 might say, "Your father is going through a very difficult time right now, and he might not be able to focus on you," or "It is okay if you feel anxious about going to his new apartment, I will be right here waiting for you." These statements seem supportive on the surface, but they plant seeds of doubt and fear in the child's mind. They suggest that the father's home is a place of instability or danger. Over 6 to 12 months, these suggestions solidify into a narrative where the child believes the rejection was their own idea. Case studies of high-conflict divorces in 2026 show that children who are subjected to this type of conditioning often develop what is known as the independent thinker phenomenon, where they insist to therapists and judges that they arrived at their negative views of their father entirely on their own, despite using adult-level legal or financial language that they could not have possibly formulated themselves. If you hear your 8-year-old child talking about marital waste, retirement account splits, or legal retainers, you are witnessing the direct evidence of coaching. In the 2026 legal system, this is your opening to move from defense to offense. The first step-by-step detail you must master is the documentation of influence. This is not just about keeping a calendar of missed visits. It is about recording the specific language the children use. When Robert's daughter told him, "Mom says we can't go to Disney World because you took all the house money for your lawyer," Robert didn't argue with the child. Instead, he made a contemporaneous note in his parenting app, documenting the date, time, and the exact quote. In a 2026 courtroom, these logs serve as a forensic map of the alienation process. The second critical step is the one legal move that can stop the poisoning of the well: the request for a guardian ad litem or a court-appointed child advocate. In many jurisdictions in 2026, a judge will not take a father's word for it that alienation is occurring, but they will listen to a neutral third party whose sole job is to represent the best interests of the child. When a guardian ad litem is appointed, they have the authority to interview the children privately, speak with teachers, and observe the home life of both parents. This professional is trained to spot the signs of coaching. They know that a child who has a healthy relationship with both parents will usually have some complaints about both. If a child describes one parent as a perfect saint and the other as a total monster, it is a red flag for alienation that most 2026 advocates will report immediately to the court. Another potential outcome to prepare for is the court-ordered 730 evaluation, which is a comprehensive psychological assessment of the entire family unit. In 2026, these evaluations have become more data-driven, often involving specialized testing designed to detect parental influence. However, be warned. An alienating spouse will often try to use the 730 process to pathologize the father, claiming his reaction to the alienation, his frustration, his sadness, or his persistence, is evidence of an unstable personality. This is why maintaining the stoic, documentation-focused approach we discussed in Part 3 is vital. If you remain the calm, consistent parent while the other side is caught in a web of documented coaching and schedule blocking, the 730 Evaluators report will likely favor an increase in your parenting time as a corrective measure. Imagine another scenario with a man named Michael in Philadelphia. Michael's teenage son was being used as a messenger for legal threats. His son would text him saying, "Mom says if you don't drop the child support demand, she's going to tell the judge about the time you yelled at her in 2022. Michael's first instinct was to call his son and explain the legal reality. This would have been a catastrophic mistake. In 2026, involving the child in the legal dispute, even to defend yourself, is viewed by the court as a form of emotional abuse. Instead, Michael took the screenshot of the text and sent it to his attorney, who filed an immediate motion for an injunction against parent-child communication regarding litigation. This order legally forbade the mother from discussing the case with the son. By using the law as a scalpel rather than a hammer, Michael protected his son from the conflict and protected his own legal standing. The psychological impact on the father during this phase is often described as ambiguous loss. You are grieving the loss of a child who is still alive, but whose personality has been altered by the conflict. Historical trends indicate that many men give up at this stage because the emotional pain of being rejected by their own children is too great. The 2026 masterclass advice is clear. Do not retreat. If you stop showing up, you are inadvertently validating the alienator's narrative that you don't care. Even if you are turned away at the door, you must show up, you must document the refusal, and you must continue to send low-pressure, loving communications that do not mention the legal case. These messages, Happy Tuesday, I hope you have a great day at school. I love you, serve as a paper trail of your consistent effort to be a father. As we conclude this deep dive into the heart of the family, you must realize that the battle for your children's minds is won through endurance and evidence, not through anger. We have covered the shift toward restrictive gatekeeping, the mask of therapeutic language, the power of the guardian ad litem, and the necessity of avoiding the trap of involving the children in the legal fight. But there is another arena where your character is being dismantled, and it is one that you cannot see from your front porch. While you are fighting for your children and your finances, there is a digital war being waged against your reputation. In 2026, your LinkedIn profile, your professional associations, and your standing in the community are all targets for a high-conflict spouse. In the next part of this series, we are going to explore the world of digital character assassination and professional sabotage. You will learn how to protect your career from a vengeful filing, the specific way to handle a call to your HR department, and the one digital privacy setting that could save your livelihood. The court of law is one thing, but the court of public opinion is where your future earning potential is truly at stake. Stay with us because the next segment is about the one thing you can't afford to lose: your name. Digital character assassination is the invisible blade of the 2026 divorce landscape. While the courtroom deals in affidavits and balance sheets, the court of public opinion deals in perception, and in the hyper-connected era of 2026, a perception shift can be more expensive than a decade of alimony. If you are a man in a high-stakes career, whether you are a mid-level manager, a licensed medical professional, or a tech executive, your professional reputation is your greatest asset. It is the engine that funds the very legal defense you are currently mounting. If that engine is sabotaged, your entire strategic position collapses. Historical trends show that as divorce has become more litigious, the battleground has moved from the family court to the LinkedIn feed and the human resources office. In 2026, the concept of the morality clause has become a standard feature in many American employment contracts. These clauses often allow a company to terminate an executive or a high-level employee for conduct unbecoming or any situation that brings negative publicity to the firm. A high-conflict spouse knows this. They understand that by making a single phone call to your HR department or tagging your CEO in a social media post, they can trigger an internal investigation that puts your livelihood on ice. Imagine a man named Christopher, a 45-year-old vice president of cybersecurity at a firm in San Jose. It is October 2026. Christopher is in the middle of a contentious asset division. His spouse, realizing that the court might not grant her the permanent alimony she desires, decides to pivot. She compiles a dossier of out-of-context text messages from a heated argument 3 years ago and sends them to Christopher's board of directors. She includes an anonymous letter alleging that Christopher's personal instability makes him a security risk for the company's sensitive data. Christopher isn't fired immediately, but he is placed on administrative leave. His stock options are frozen, and his professional standing is decimated. This is the 2026 reality of professional sabotage. To survive this potential outcome, you must implement a professional preemptive strike. This is a step-by-step counter-strategy that begins the moment you realize a divorce is imminent. Step 1. The HR disclosure. In the 2026 corporate environment, being the first to frame the narrative is vital. You do not need to share the gory details of your marriage. Instead, you schedule a brief, formal meeting with your HR representative or your direct supervisor. Use a script that focuses on transparency without emotionality. For example, I wanted to let you know that I am currently navigating a high-conflict divorce. My priority remains my performance and my responsibilities here, but I wanted to make you aware of the situation in case any outside parties attempt to contact the firm with personal grievances. By doing this, you have labeled any future incoming attacks as what they are: personal grievances from a legal adversary. Case studies from 2025 show that employees who disclose early are 40% less likely to face termination following an anonymous tip compared to those who remain silent. Step 2. Digital lockdown and the LinkedIn scrub. In 2026, social media is a forensic goldmine for a vengeful spouse. Every photo of you at a happy hour or a late-night office party can be recontextualized as evidence of a substance abuse problem or neglect of parental duties. You must immediately switch your LinkedIn to private mode. This prevents people from seeing when you are looking at their profiles and limits who can see your connections. Beyond that, you must perform a digital audit. In 2026, we see a rise in divorce talk and storytime culture, where spouses post videos detailing their grievances. You need to set up Google alerts for your own name and your company's name. If a video or post begins to gain traction, you don't respond to it directly. Instead, you provide the link to your attorney, who can file for an emergency gag order or an injunction against the dissemination of private, defamatory material. Historical trends also indicate a rising threat to those with professional licenses. If you are a doctor, a pilot, a lawyer, or a teacher, you are particularly vulnerable to license jeopardization. In 2026, many state licensing boards have adopted a zero-tolerance policy for any domestic violence allegations, even if they have not been proven in a criminal court. Imagine another scenario with Daniel, commercial airline pilot living in Chicago. Daniel's spouse files a temporary restraining order or TRO based on a verbal argument. Because Daniel's job requires a federal security clearance and a pristine background check, the mere existence of the TRO triggers an automatic suspension of his flying credentials. He is grounded for 6 months while the case wins through the system. During that time, he loses half a year of seniority and nearly $150,000 in income. The strategy for men like Daniel is the immediate legal carve-out. Your attorney must be instructed to fight for a specific provision in any temporary order that explicitly states the order is for civil purposes only and does not constitute a finding of criminal conduct or a threat to public safety. In 2026, savvy family law attorneys are working with employment lawyers to draft language that satisfies the court's need for a cooling-off period without triggering the mandatory reporting requirements of professional boards. If you do not have this carve-out, you may win your divorce but lose your career. We also have to address the network defense. In the tight-knit professional circles of 2026, your name is your currency. A high-conflict spouse may attempt to poison your relationships with mentors, clients, or industry peers. The temptation is to go on a counteroffensive and tell everyone your side of the story. Do not do this. In the eyes of your professional network, the person who complains the loudest is usually seen as the problem. The most effective defense is to maintain a quiet professional persona. When people ask how you are doing, the answer is always, "I'm focused on my work and my family, thank you for asking." By refusing to participate in the drama, you make the other party look like the sole source of the conflict. The final layer of character protection involves the financial paper trail of defamation. If your spouse's actions lead to a loss of income, a demotion, or the loss of a client, you must document the exact dollar amount of that loss. In 2026, courts are becoming more receptive to the idea of recoupment. If it can be proven through forensic evidence and witness testimony that your spouse intentionally sabotaged your career, A judge may offset their share of the marital assets to compensate you for the lost income. This isn't just about revenge. It's about the math of the marital estate. If they destroyed the value of the asset, which in this case is your earning capacity, they should be the ones to bear the cost. Case studies in high-conflict jurisdictions show that men who treat their reputation as a business asset, securing it with disclosures, protecting it with digital privacy, and defending it with targeted legal filings, emerge from the process with their career trajectory intact. Those who ignore the digital and professional front usually find that by the time the divorce is final, there is no career left to support their new life. As we conclude this part of the masterclass, you should recognize that the court of law and the court of public opinion are now inextricably linked. We have covered the weaponization of HR, the necessity of the preemptive strike, the protection of professional licenses, and the financial recovery of sabotaged earnings. But even with your reputation secured and your finances guarded, there is one final, daunting hurdle. The ultimate test of your endurance isn't the rumors or the bank statements. It is the moment you step into the courtroom for the final trial. In the next part, we are going to pull back the curtain on the judiciary mindset of 2026. You will learn the 3 things every judge is looking for in a father, the specific body language that can sink your case in seconds, and the one question you must never answer without a specific legal qualifier. The battle for your name is almost over, but the battle for the final judgment is just beginning. Stay with us because the endgame is where the most significant mistakes are made. To understand the judiciary mindset of 2026, you must first recognize that the American family court judge is an individual operating within a high-volume, high-stress administrative machine. In major metropolitan hubs across the United States, a single judge may oversee thousands of cases a year. By the time your case reaches a final trial, that judge has likely heard every possible variation of domestic conflict. They have developed a professional cynicism that acts as a filter. They are not looking for who is the better person, they are looking for who is the more stable parent. In the 2026 legal climate, stability is defined by 3 specific pillars: emotional regulation, structural consistency, and facilitation of the other parent. Imagine a man named Jonathan, a 39-year-old high school principal in Columbus, Ohio. It is November 2026, and Jonathan is sitting in a wood-paneled courtroom for his final custody hearing. His spouse's attorney is aggressively questioning him about a series of frustrated text messages he sent 18 months ago. In 2026, the courtroom is often a hybrid environment, with digital evidence screens flanking the judge's bench. As those texts are displayed in giant font for the court to see, the judge isn't just reading the words, the judge is watching Jonathan's face. This is where the body language of the endgame becomes a legal asset. Historical trends in 2026 show that judges are increasingly biased toward the parent, who demonstrates the highest level of executive function. If Jonathan sighs, rolls his eyes, or slumps in his chair as his mistakes are broadcast, he is signaling to the judge that he is easily rattled and emotionally immature. Instead, Jonathan maintains what we call the clinical observer stance. He keeps his back straight, his hands visible on the table, and his expression neutral. He looks at the judge, not the opposing attorney, when answering. This nonverbal communication tells the court that Jonathan is a man who can remain calm under pressure, a vital trait for a parent navigating the complexities of a 2026 co-parenting schedule. The first thing a judge is looking for in a father is structural consistency. In the 2026 Masterclass of Courtroom Strategy, this means you must provide a granular, day-to-day blueprint of your life as a single father. Do not speak in generalities about being a good dad. Instead, you must present a parenting portfolio. This is a physical or digital document that includes your proposed 50-50 schedule, a map of the distance between your home and the children's school, a list of nearby pediatricians, and even a plan menu for your weeks with the kids. Case studies show that fathers who present a proactive plan rather than a reactive defense are 60% more likely to secure their desired parenting time. The judge wants to see that you have already built the world the children will inhabit. The second pillar is facilitation. This is the most counterintuitive part of the 2026 judiciary mindset. The judge is looking for the parent most likely to encourage a healthy relationship with the other parent. Even if your spouse has spent the last year trying to destroy your reputation, your testimony must be focused on your desire for the children to have both parents in their lives. If you come across as vindictive or as someone who wants to win by cutting the other parent out, the judge may view you as the alienating parent. This is a potential outcome that many men face because they confuse their quest for justice with the court's quest for the child's stability. This brings us to the trap question that every man must be prepared to answer in 2026. During cross-examination, the opposing counsel will likely ask, "Do you believe the mother is a fit and proper parent?" Most men feel a surge of anger at this question, especially if they have been subjected to the tactics we discussed in previous modules. If you say no, you appear high conflict and unwilling to co-parent. If you say yes, you might feel like you are undermining your own case for primary custody. The specific legal qualifier you must use in 2026 sounds like this: "I believe she has the capacity to be a fit parent. However, I have significant concerns about her recent pattern of, and I believe the structure of my proposed parenting plan provides the necessary safeguards for the children's best interests." By answering this way, you are not attacking her character. You are attacking her recent patterns with evidence, while still appearing to be the reasonable, facilitating father the judge wants to see. Beyond the testimony, we must address the AI-enhanced evidence review that has become standard in 2026. Many American jurisdictions are now using software to scan thousands of pages of communication logs to identify patterns of coercive control or high-conflict temperament. If your digital history shows that you are the one always initiating the arguments, the software will flag you. Step by step, you must ensure that your digital footprint for the 6 months leading up to the trial is pristine. This means no late-night emails, no multi-paragraph text messages, and no responses to baiting comments. In 2026, the man who speaks the least in writing often has the strongest voice in court. Imagine if Jonathan had fallen into the trap of responding to his spouse's provocations. The AI summary provided to the judge would have shown a high conflict dynamic between both parties, often leading a judge to default to a 223 or 255 schedule that might not be in the children's best interest. Because Jonathan used a brief, informative, friendly, and firm BIF communication style, the AI report showed him as the stable, non-reactive party. The judge, seeing this data, felt confident in granting Jonathan the 50-50 split he was fighting for. We also have to discuss the financial affidavit endgame. In 2026, many men make the mistake of trying to tweak their numbers at the last minute to lower child support or alimony. This is a catastrophic error. Forensic tools used by the courts can now instantly cross-reference your lifestyle with your reported income using 1099K data from payment apps and credit card spending patterns. If you claim you only make $5,000 a month but your Uber Eats, Amazon, and travel expenses average $7,000, you have just handed the judge a reason to find you incredible, meaning they will not believe anything else you say. In the 2026 courtroom, total transparency is the only way to protect your long-term assets. As the final trial concludes, there is a specific feeling of the weight. In 2026, judges rarely rule from the bench. They take the case under advisement, meaning you might wait 2 to 4 weeks for a written decree. This period is a historical trend of high stress for men, often leading to victory laps or post-trial venting on social media. You must understand that until that decree is signed, sealed, and delivered, you are still under the microscope. Any lapse in judgment during this waiting period can lead to a motion to reopen the case. The 2026 judiciary mindset is ultimately about risk mitigation. The judge wants to sign an order that they will never have to see again. They want a plan that is so clear, so detailed, and so stable that it prevents future conflict. By positioning yourself as the architect of that stability, you move from being a defendant to being a partner in the court's mission to resolve the case. But even with a successful final judgment in your hand, the journey is not over. The transition from the courtroom back to the real world is where the next set of challenges begins. Many men win their case only to find that the new normal is harder than the battle itself. In the next part, we are going to dive into the post-decree reset. You will learn how to navigate the first 90 days of your new parenting schedule, the specific way to handle parenting app baiting after the judge is gone, and the strategy for rebuilding your social and financial life from the ground up without triggering a modification filing from your ex-spouse. The war in the courtroom is done, but the peace is something you have to build brick by brick. Stay with us because the first few months of your new life will dictate the next 20 years. The post-decree reset is the phase where most men believe they have reached the finish line, only to discover they have actually entered a high-stakes marathon of compliance. In the American legal system of 2026, the signing of the final judgment is not a shield, it is a rulebook. If you deviate from that rulebook, even with the best of intentions, You open the door for a modification filing that could undo years of legal work and tens of thousands of dollars in legal fees. Historical trends in family law suggest that the first 12 months post-divorce are the most critical for establishing a pattern of stability that prevents future litigation. Imagine a man named Brandon, a 44-year-old logistics manager in Atlanta, Georgia. It is January 2026, and Brandon has just received his final decree granting him a true 50-50 parenting split. He feels a massive sense of relief. In February, his ex-spouse calls him and asks if she can keep the children for an extra weekend because her sister is in town. Brandon, wanting to be the nice guy and move past the conflict, agrees verbally. He thinks he is building goodwill. However, 3 months later, Brandon asks for a similar favor, and his ex-spouse refuses. When Brandon insists on his court-ordered time, his ex-spouse points to the previous months and says, "You were fine giving up your time then, so clearly you don't need the full 50-50. This is a common case study in the trap of informal agreements. In 2026, any deviation from the court order that is not documented and confirmed in a court-approved parenting app is a potential liability. Step 1 of your post-decree strategy is the implementation of the letter of the law protocol. For the first 90 days, you must follow the parenting schedule exactly as it is written, down to the minute of the exchange. If the exchange is at 6 p.m. at a neutral location, you arrive at 5:50 p.m. and stay until 6:10 p.m. You do not offer favors and you do not ask for them. This creates a historical trend of perfect compliance. If your ex-spouse attempts to file for a modification 6 months later, claiming you are unreliable, your data-backed record of perfect attendance in the parenting app will make their claim look frivolous to a judge. In 2026, consistency is your only defense against the accusation of being an absentee or inconsistent parent. This brings us to the evolution of parenting app baiting in 2026. Now that the judge is no longer actively watching the case, a high-conflict spouse may transition from legal attacks to psychological ones, using apps like Our Family Wizard or Talking Parents. You might receive a message that is 3 paragraphs long, filled with accusations about your parenting style, your new living situation, or your character. The goal of this baiting is to get you to respond with an angry or defensive message that can then be used as evidence of a high-conflict temperament in a future modification hearing. To counter this, you must master the gray rock method of communication. This means becoming as uninteresting and non-responsive as a gray rock. When you receive a long, emotional message, your response should be limited to the 3 Fs: factual, functional, and firm. If the message contains 50 insults but one question about what time you are picking up the children, your response is, "I will be at the exchange location at 6 p.m. per the court order." You ignore every insult, every dig at your past, and every emotional hook. Case studies from 2025 show that men who utilize the gray rock method in 2026 reduce the frequency of high-conflict messages by 70% within the first 4 months, as the alienating spouse loses interest when they can no longer get an emotional rise out of you. Financially, the post-decree reset requires a surgical approach to your new reality. Many men in 2026 fall into the trap of revenge spending. After years of being told how to spend their money or being restricted by a marital budget, there is a psychological urge to buy the house, the car, or the trip that they always wanted. However, imagine a scenario with a man named Steven in Denver. Steven finally settles his case and immediately buys a high-end luxury SUV to celebrate his new life. His ex-spouse sees the car on social media and immediately instructs her attorney to file a motion for an upward modification of child support, arguing that Steven's lifestyle suggests a material change in circumstances or undisclosed income. In 2026, your lifestyle is your testimony. You must maintain a modest, documented financial profile for at least 1 year following the decree to ensure the dust has fully settled on your support obligations. Rebuilding your credit in 2026 is another step-by-step necessity. Following the financial firebreak and the asset split, your credit score may have taken a significant hit due to the closing of joint accounts or the high utilization of personal cards for legal fees. You must immediately open a secured credit card if necessary and begin a process of rapid debt reduction. Historical trends show that men who successfully reconstitute their financial life within 2 years of a divorce are 50% more likely to maintain their 50-50 custody arrangements, simply because they have the resources to provide a stable, high-quality environment for their children. We also have to address the social pivot. In the wake of a 2026 divorce, you may find that your social circle has been halved. Many of your married friends may feel uncomfortable around you, or they may have felt forced to take a side. This is where the cultural shift of 2026 comes to your aid. We are seeing a rise in men-only professional and social networks that focus on post-divorce growth rather than bitterness. Joining these groups is not just about emotional support. It is about networking with other men who have navigated the same legal system. They can provide recommendations for forensic accountants, therapists for your children, or even career opportunities that fit your new parenting schedule. One of the most dangerous potential outcomes in this phase is the Disney dad syndrome. This is when a father, feeling guilty about the divorce or the limited time he has, spends his entire parenting week taking the kids to theme parks, buying them expensive gifts, and avoiding any form of discipline. In the 2026 legal landscape, this is a trap. An observing guardian ad litem or a therapist will view this as an inability to provide a structured, healthy environment. Your children do not need a tour guide. They need a father. Step by step, you should focus on building a routine that includes chores, homework, and quiet time at home. This shows the court that your house is a place of growth and stability, not just a vacation destination. Finally, you must understand the legal threshold for a material change in circumstances. In most American states in 2026, a court order cannot be changed unless one party proves that something significant has shifted since the last decree was signed. This could be a job loss, a relocation, or a change in the child's needs. Your goal in the post-decree reset is to ensure that no such change is triggered by your actions. If you decide to move, stay within the mileage radius defined in your decree. If you change jobs, try to ensure the income is comparable so you don't trigger a support review. As we conclude this part of the masterclass, you are standing on the threshold of your new life. You have the decree, you have the strategy for compliance, and you have the tools to protect your peace. But there is one final question that haunts every man who has been through this process. How do I ensure that this never happens again? And more importantly, how do I turn this survival story into a legacy of thriving? In the 10th and final part of this series, we are going to look at the long-term vision. We will explore the 2026 trends in prenuptial agreements for second marriages, the psychology of healthy relationship rebuilding, and the one mindset shift that moves you from being a victim of the system to a master of your own future. The war is over, and now it is time to build your empire. Stay with us for the conclusion of the Cultural Shifts Masterclass. The transition from a state of total defense to a state of visionary offensive begins with the recognition that your old life is not something to be mourned, but a rough draft for the masterpiece you are about to create. In the 2026 landscape, the man who has successfully navigated the American divorce machine is not a broken individual. He is a refined one. He has been through the high-stakes crucible of the legal system. He has had his finances audited, his character questioned, and his parental bond tested. This process, while exhausting, often results in a clarity of purpose that most men never achieve. This final module is about taking that clarity and turning it into a fortress. Building your empire in 2026 requires a fundamental shift in how you view the concept of wealth. Historical trends show that men who have lost 50% or more of their net worth in a divorce often rebound with a more aggressive and diversified investment strategy. Imagine a man named Thomas, a 48-year-old architect in Chicago who, after a 3-year legal battle ending in May 2026, was left with a depleted retirement account and a mountain of legal debt. Instead of falling into the trap of despair, Thomas utilized a strategy known as the Financial Phoenix Protocol. Step by step, he moved away from traditional low-yield marital investments and focused on high cash flow assets. He leveraged his professional expertise to start a niche consulting firm, utilizing 2026 tax codes that favor solo entrepreneurs. Within 18 months, his monthly cash flow exceeded his pre-divorce household income. The potential outcome here is not just recovery, but the creation of a wealth structure that is more resilient and entirely under your control. In the current year, the 2026 Financial Toolkit for Men also includes a heavy focus on asset protection trusts and decentralized financial vehicles. Many men who have been through the divorce machine now understand that any asset held in a standard joint account, or a traditional 401k, is vulnerable to the whim of a family court judge. As a result, we are seeing a historical trend of men shifting their wealth into protected entities that are legally distinct from their personal name. By utilizing spendthrift trusts or domestic asset protection trusts in states like Nevada or South Dakota, a man can ensure that the empire he builds for his children is shielded from future litigation. This is not about hiding money. It is about utilizing the same legal structures that high-net-worth individuals have used for decades to ensure that their legacy remains intact regardless of their marital status. As you begin to move back into the world of dating and relationships, you must understand the prenuptial revolution of 2026. The days of the simple 5-page prenuptial agreement are over. In the modern era, men are utilizing what legal scholars call the lifestyle and financial sovereignty contract. These are sophisticated documents that go far beyond who gets the house. They include specific sunset provisions, where the terms of the agreement change based on the length of the marriage, and detailed clauses regarding the division of future business growth. Imagine if Thomas meets a new partner in late 2026. Because of his past experience, he insists on a prenuptial agreement that includes a separate property affirmation. This clause ensures that the business he built post-divorce and any appreciation of those assets remain his alone, regardless of the marriage's duration. Furthermore, 2026 trends show the inclusion of infidelity clauses in social media non-disparagement agreements. These are designed to mitigate the digital character assassination we discussed in Part 7. By setting the rules of engagement before the first I do is spoken, you are protecting not just your money but your mental peace. Case studies suggest that marriages with well-defined prenuptial agreements in 2026 actually report higher levels of satisfaction because the financial power dynamics are transparent from day one. The psychology of the 2026 man also involves a radical shift in how he approaches co-parenting. We are moving away from the era of the weekend visitor and into the era of the impact father. Even if you have a 50-50 split or less, the quality of your time must be elevated. Historical trends in child development show that children do not necessarily need a high volume of hours. They need high-quality mentorship. In 2026, men are utilizing the parenting mastermind model, where they treat their time with their children like a high-level coaching session. This involves teaching the children financial literacy, emotional resilience, and the very legal awareness that you had to learn the hard way. By doing this, you are ensuring that the cycle of family court ends with you. You are turning your struggle into a curriculum for the next generation. However, the most significant potential outcome of this entire 10-part journey is the internal transformation. The cultural shift we have been discussing throughout this masterclass is ultimately a shift in male consciousness. For decades, men were told that their value was solely tied to their role as a provider within a specific, rigid marital structure. The 2026 divorce machine has proven that this structure is fragile. The new man, the man who survives and thrives, is one who finds his value in his own character, his professional excellence, and his unshakable bond with his children, independent of any state-sanctioned contract. You must also be aware of the rising trend of men-only professional masterminds. In 2026, these are not just social clubs. They are specialized networks where divorced men pool their resources, share legal strategies, and offer high-level career opportunities to one another. Being part of such a network is a critical step-by-step detail in your long-term success. It provides the social support that the legal system often strips away. It serves as a reminder that you are not an island, and your success is a win for the entire community of men who are navigating this shifting cultural landscape. As we conclude this deep dive masterclass, it is important to reflect on the open loop we created at the beginning of this series. We talked about the dismantling of the old social contract. That dismantling is complete, but in its place, a new, more honest contract is being written by men like you. Men who are informed, prepared, and focused on the long-term vision. The path forward is not easy, and the legal system will continue to evolve, often in ways that challenge the status quo. But with the strategies we have covered, from the financial firebreak to the parenting log, from the professional preemptive strike to the judiciary mindset, you are no longer a passenger in your own life. You are the pilot. The empire you build today will be built on the lessons of your past. Every dollar you recover, every hour of parenting time you secure, and every boundary you enforce is a brick in that foundation. The American legal system is a machine, but you are the ghost in that machine, the variable that it cannot fully account for. By staying disciplined, staying documented, and staying stoic, you have not only survived a cultural shift, you have mastered it. While this concludes our 10-part masterclass on divorce and cultural shifts, the landscape of 2026 continues to change at a rapid pace. The strategies that work today may need refinement as new laws are passed and new technologies emerge. This is why our next series will focus on the specific legal and financial shifts coming in 2027, including the impact of the newly proposed Family Court Transparency Act and the rise of AI-driven mediation. The war for your future never truly ends. It just changes form. Stay sharp, stay informed, and continue to build your empire. The best version of your life is not behind you. It is currently under construction,